The Indian judicial system has the following as its main sources of law: the Constitution, statutes, customary law, judicial decisions. The Constitution of India is the supreme source of law. Statutes are enacted by the Parliament or the state legislatures. At the local level, subordinate delegated legislation such as rules, regulations, and bylaws is passed by local authorities such as government departments, municipal corporations, municipalities, and gram panchayats. Customary law in certain aspects, local customs and conventions, usually religious in nature, that are not against any statute or morality are also applicable. Judicial decisions. While technically not law, judicial decisions of superior courts like the Supreme Court of India and High Courts are another important legal source, and they ultimately have precedential value. General court structure and hierarchy. The Supreme Court of India, which is situated in Delhi, is the highest court in the country. Subsequently, there are 24 high courts. Although certain high courts have authority over several states and union territories, each state has its own high court. In the northeastern region of India, for instance, the Guwahati High Court has jurisdiction over the states of Assam, Nagaland, Mizoram, and Arunachal Pradesh, all of which are close to each other. States are further divided into districts for administrative convenience, and each district has its own district court. With a few exceptions, the district court has original jurisdiction over both criminal and civil cases. The judicial system is also composed of commissions and tribunals that were created in accordance with certain statutes and that deal with those statutes. To what extent are lower courts bound by the decisions of higher courts? All Indian courts, judicial agencies, and tribunals are required to follow the Supreme Court of India's ruling as precedent. Similar to this, until another high court rules to the contrary, rulings of the high courts are binding on all lower courts, authorities, and tribunals in India. If another high court issues a contrasting ruling, the ruling from the high court with a higher judge bench typically stands. Any other court is not bound by district court rulings. Are there special courts for certain legal areas? Under the Indian judicial system, certain traditional courts have been specifically tasked to deal with certain areas of law. District courts usually have courts formed under specific statutes, such as family courts, to deal with issues relating to marriage, inheritance, guardianship of minors, and maintenance. The Special Court of the Central Bureau of Investigation, to deal with cases of corruption and bribery. Some high courts and district courts which house commercial courts, which deal only with commercial matters of specific value, including matters relating to arbitration. With the socialist aim of making legal remedies accessible and affordable to all, Indian judicial system has constituted lok adalats and gram panchayats at the village level. These bodies apply traditional or customary laws and primarily work towards settling local disputes by using alternative dispute resolution mechanisms. Apart from the courts, the Indian judicial system comprises of tribunals, commissions, and quasi-judicial authorities that derive their authority from specific statutes. We will be seeing more of these in our next video on quasi-judicial bodies. Independent judiciary. There are several provisions under the Constitution of India that ensure an independent judiciary. Appointment regarding a member of the judiciary. State public service commissions or the high courts are responsible for appointing judges to the highest courts of the subordinate judiciary. Typically, these consultations are established based on results from specific exams, that is, the lower judicial service examination or higher judicial service examination. Judges from the lower courts frequently receive promotions, and some are even chosen to serve as High Court or Supreme Court judges. Litigation, civil and criminal. Do the courts use an adversarial, non-adversarial, or other system when it comes to litigating civil and criminal matters? Indian law is primarily adversarial in nature. However, it combines adversarial and inquisitorial duties in some instances. Due to several elements in the criminal law that permits the judge to exercise investigative duties, the criminal justice system in particular is not strictly adversarial. The judge will, for instance, actively direct further research and other fact finding activities in order to formulate charges. Gathering evidence. Generally, the party seeking to establish a fact or allegation is responsible for gathering and producing evidence. In civil cases, the claimant is usually required to gather evidence, but assistance from the court is permitted for the discovery of documents and setting up commissions. In criminal cases, the law enforcement agencies are responsible for investigating and gathering evidence. Therefore, police authorities and specialized investigating agencies have been given wide powers of summoning, search, seizure, and examination. Criminal courts have wider powers to gather evidence than civil courts as they can issue warrants of arrest, proclamations for enforcing a person's presence before the court, either for making a statement or for producing a document. That being said, the judges must usually play a neutral role in both civil and criminal matters. Are trials or hearings open to the public? Barring a few exceptional circumstances where trials or hearings are conducted in camera, all trials or hearings, whether civil or criminal, are open to the public at large. The Constitution of India provides that the judgments of the Supreme Court must be delivered only in the open court. Civil law. All civil courts are open courts and are generally accessible by the public. This is subject to the discretion of the judge who may want to avoid the public or any particular person from attending the court. Evidence of witnesses is also required to be taken in open court. Criminal law. Much like civil courts, all criminal courts are also open courts. The recognized exception to the principle of the open court is private proceedings in certain sensitive matters at the discretion of the court. They are usually matters that call for anonymity of the victim, such as matters involving rape or matrimonial disputes. In such cases, proceedings are carried out in private through video conferencing. The main purpose of a trial. The petitioner or the claimant and the defendant are the major parties in legal cases. The state prosecution and the accused are the principal parties in criminal cases. The primary purpose of a trial is for the court to evaluate the evidence at hand, balance it, and then reach a verdict. A trial often involves questioning and cross-questioning of witnesses, questioning of defendant, and the examination of evidence. In some circumstances, the court may even order some research to be conducted to gather proof while the trial is still going on. What is the main role of a judge and a counsel in a trial? Role of judiciary. In line with the adversarial system, the judge is a neutral arbiter. He or she facilitates the trial, weighs the facts of the case, and considers the evidence collected against the standard of proof. However, judges have wide powers under both civil and criminal law, not only to examine the parties or witnesses, but also to compel a person who is relevant to the hearing to attend court and give evidence. Role of legal counsel. Legal counsel in India are officers of the court. They must assist the courts by properly adjudicating the dispute in the administration of justice. The counsel must also advise the client, keep client information confidential, unless it is required to be disclosed by law, and represent them in legal proceedings in the best possible manner. Burden of proof. The burden of proof in both civil and criminal proceedings is either on the party that would fail if no evidence were given on either side, the party asserting a claim or who intends to persuade the court of any fact. If any fact is in the special knowledge of a person, the burden of proof is on that person to prove the fact. This rule applies in all situations unless an exception is created by law. However, if the statutory or legal threshold is met by one party, the burden of proof shifts to the other side. For example, in proving the existence of a document, if a party adduces a photocopy, if the original is unavailable and the other party claims the document is forged, the other party has the burden to prove its forgery. Civil law. In a civil suit, the standard of proof is the preponderance of probabilities. That is, the occurrence of something in a certain manner was more likely than not. Criminal law. Generally, in criminal matters, the standard of proof is to establish guilt beyond all reasonable doubt. However, departing from the general rule of evidence in certain criminal or penal provisions, such as dowry, death, or custom evasion, the law requires meeting a bare minimal threshold by the prosecution to presume the guilt of the accused. The burden of proof otherwise then lies on the accused. What types of verdicts can the court give? Civil law. In a civil suit, depending on the relief sought and the outcome of the case, the courts can give a variety of verdicts. A verdict in favor of the claimant will typically be a money decree, a declaratory decree, or both. A verdict in favor of the defendant may result in the claimant being ordered to pay costs, if necessary. Criminal law. In criminal matters, the verdict can be either a conviction or an acquittal. Where more than one person is accused, the court can convict some parties and acquit the rest. Range of penalties or relief. Civil law. On reaching a verdict, a civil court can grant all or any of the monetary or declaratory reliefs sought by the claimant in its claim before the court. A civil court will not usually grant any relief which is either not sought at all or is beyond what has been sought. Monetary reliefs can be general damages, whether liquidated or unliquidated, for a breach of contract or special damages in special circumstances. Criminal law. After a guilty verdict, depending on the nature of the crime and the statutory penalty prescribed, the criminal court can sentence the convict to simple or rigorous imprisonment, ranging from few months to imprisonment for life or a death penalty. A fine can also be imposed if permitted under the statute. Upon conviction of corporate entities, Indian criminal law does not permit imposing punishment on their officers, unless specifically permitted by a statute. If you watched this video so far, I'm sure you found it interesting. I would urge you to like this video and subscribe to our channel.